All right, welcome back. I hope you're all excited because, as promised, at long last, we're going back up to Idaho. We are returning to the case Scofield versus Guillard, the TikTok psychic case, the Dingleberry to the Idaho murders case. It just the absolute mess that it is. And so I'm doing a marathon recording session. So most of you are seeing this the day after, but I'm recording it right after I recorded my Alec Baldwin update about the case being dismissed with prejudice due to fuckery. But some of you will see it earlier because I've decided in marathon recording sessions, I'm going to release them, one a day. Except for members, you get them when they're uploaded. So if you're a member, hello on Saturday, probably, I think. If you're not a member, hello probably on Sunday. Unless you're in the upside down, then, tack a day onto that, I guess, maybe, probably. I think that's how time works, but either way. So yeah, it's been ages since we've visited Idaho, which I've missed it. It's a beautiful state. Never been quite so far north as Moscow, but just been distracted by the Karen Reed clusterfuck. So either way, we are back, and a quick update. So you'll recall there was all kinds of fuckery on the part of the defendant, Ashley Guillard. In the beginning, she was in default, but not a default judgment. And then, pretty please, judge, I promise to behave if you let me actually defend the case. And she hasn't behaved. So where we left off, scrolling. I even had to look at my last video I made on it to see for sure. Is I believe we did docket number 63 and possibly 64. They're both basically the same thing. But so docket 63, Jesus, that was all the way back in January. Either way, docket 63 was the amended motion for partial summary judgment, because you'll remember Professor Scofield brought a motion for summary judgment, which should have been granted. Summary judgment is where you ask the judge to say, yeah, so we win, right? Yeah. And it's a partial summary judgment because they still have to have a jury decide how much they win, because it's defamation, not a contract. It's not for a sum certain. So when they brought their initial motion for summary judgment, it was, it was, hey, Guillard hasn't behaved. She hasn't responded to the request for admissions, the whole discovery thing. Therefore, she's admitted to everything. Therefore, we really extra win because, she's admitted to everything. Well, the court said, well, we'll give her one more chance to respond to discovery. So that was the January amended motion for summary judgment, for partial summary judgment. And then you'll notice that was on January 12th. Also on January 12th, we had a motion for leave to file an amended summary judgment, or an amended complaint, sorry, to add punitive damages. So basically, it was, hey, so under Idaho law, we can't ask for punitive damages until we've made a showing and, discovery's complete. And hey, we're entitled to punitive damages now, or at least to ask for them. So we need to file an amended complaint, even though discovery is closed. And the exhibit A was, well, sorry. Either way, they included the proposed amended complaint, and literally it added like 3 lines. It was, Guillard's admitted to this, this, and this. She made one more video, and punitives. I can't remember if we covered that. Either way, there's not a whole lot to it. So where we are today is, to make this digestible, we're going to look at docket 65 and 66, which are, as far as I can tell, identical. 67 and 68, and then we'll come back for the next video beyond that. And like I said, we're so far behind that we've got a couple more videos to get caught up. But either way, so what have we got? So 65 is the response to the motion to amend, to basically it's the response to the summary judgment motion. And then 66 is the response to the motion to file an amended complaint. And it would appear that Ashley Guillard basically made one document, one response, and filed it twice, which a lawyer wouldn't do that. Shouldn't do that. She did. She's not a lawyer. She doesn't even play one on TV. So, like I said, we'll do 65 and 66 because they look the same. And then we will do 67, which is Professor Scofield's reply in support of the motion for partial summary judgment. And 68, which is Professor Scofield's reply in support of the motion to file an amended complaint. So basically 65 and 66 are separate motions that are identical, filed twice for 2 separate purposes. And because they're filed for 2 separate purposes, to that one motion, basically, we get 2 replies because it is 2 separate motions. So Professor Scofield, having the former Idaho U.S. attorney as her attorney, she's kind of good at this, and so she's following the rules. So that said, that's our roadmap for today. We're going to do our best to scoot through it and not turn this into a 3-hour video, as I kind of sometimes am known to do. But either way, didn't want to do that. So this is, as I mentioned, defendant's response to plaintiff's motion for leave to amend complaint to add punitive damages. Although, so it like I said, this is docket number 66, but as far as I could tell, it's identical to 65, which was the defendant's response to partial summary judgment. So same thing, just, yeah. So comes now defendant Ashley Guillard in opposition to plaintiff Rebecca Scofield's motion for leave to amend complaint to add punitive damages. Idaho Code section 6-1604 requires that the claimant must prove by clear and convincing evidence oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. Plaintiff Rebecca Scofield has not proven that defendant Ashley Guillard to be wrong. That's some good grammar. Nor has the plaintiff proved by clear and convincing evidence that Guillard has behaved maliciously, fraudulently, outrageously, or oppressively. Additionally, Scofield's request does not meet the intent or requirements of Rule 15 of the Federal Rules of Civil Procedure. The court must deny Scofield's motion for leave to amend complaint to add punitive damages. And like I said, they do appear to be basically the same, but let's actually take a peek at no. $67. Okay, that's would help if I click on the right one. I wanted that one. 65. And so basically the intro, I guess, is what's different. So comes now defendant Ashley Guillard in opposition to the professor's motion for partial summary judgment for several reasons. Plaintiff Rebecca Scofield's motion must fail. First, the plaintiff does not meet the criteria for a summary judgment under Rule 56. There is an issue of material fact, and Scofield is not entitled to judgment as a matter of law. Second, Guillard has not defamed Scofield, nor has she admitted to defaming Scofield. Third, the burden of proof in defamation cases rests on the plaintiff. Scofield has not proven the statements Guillard made about her are false. Therefore, as it stands, the statements are legally presumed to be true. For those reasons and more, the amended motion for partial summary judgment must be denied. No, I don't know where the hell she gets this notion. Therefore, it stands the statements are presumed to be true. No. They do not. They are not presumed to be true. For the purposes of a motion to dismiss, the statements are presumed to be true. But it's the allegations of the plaintiff are assumed to be true for the purposes of the defendant's motion to dismiss. The court is under no obligation to assume the truth in anything Ashley Guillard has said. I mean, in dismissing her counterclaims, yeah, sure. But here, this isn't even a motion to dismiss, though. This is a motion for summary judgment. And in a motion for summary judgment, it's undisputed facts. I love how ad blocker, every time you open a new tab, ad blocker gives you an ad for ad blocker. It's almost like we need an ad blocker against ad blocker. So let's look at the exact language in Rule 56, summary judgment. So a party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and that the movement is entitled to judgment as a matter of law. Here, that she is. So let's go back. So we'll take a peek at the amended statement of undisputed facts that Professor Scofield has submitted. She's an associate professor of history and a department chair. Guillard is a resident of Texas. So Guillard has admitted she has never been to the state of Idaho. She has never been to Moscow, Idaho. These are undisputed facts. At the time of the murders, Professor Scofield was not in Idaho. Guillard made videos uploaded to TikTok, undisputed fact. And in those videos, accused Professor Scofield of murder. Let's see. Let's find the good bits. So Ms. Guillard is not aware of any physical evidence linking Professor Scofield to the murders, and that's request for admissions number 9 response. She claims there's plenty of evidence to be discovered during the civil discovery process, which has closed. Discovery has ended. She has no written information that shows Professor Scofield ever met any of the students. Request for admissions 15, 17, and 19 in the responses. She has not received any information orally from another human being showing that Professor Scofield ever met the students. Let's see. So, no physical evidence showing Professor Scofield had a romantic relationship with any of the students. Cease and desists. Ms. Guillard was aware of the press release saying that Professor Scofield was not involved in the murders. Ms. Guillard has no evidence that she ever communicated with the alleged accomplice. Doesn't have any written information showing that Professor Scofield ever met the accomplice. Ms. Guillard states that Professor Scofield has not proven that she didn't have an affair with the student, or that she was not involved in the murders. The thing is, how do you prove a negative? How do you prove a negative? Seriously. Whereas, the truth being an affirmative defense in a defamation case. In order for Ashley Guillard to use the truth as a defense, she has to show the truth. She hasn't, because the truth isn't on her side. If she had facts to show Professor Scofield had done any of these things, it's Ashley Guillard's job to show them. She hasn't. But back to it. We will read this one just because it's the first one. So, and by first one, I mean this is the opposition to summary judgment as opposed to the opposition to the amended complaint adding punitives. But other than the bits we've already read from this point on, I believe they're both basically the same. So at least we're going to treat them that way. So background: the murder of the 4 University of Idaho students. On November 13th, 2022, 4 students at the University of Idaho, referred to as the 4 students, out of respect for the 4 students, I like to leave their names out of this because, frankly, this is a circus that they don't deserve to be dragged into. And it's disgusting that Ashley Guillard has done that. So I refer to them where I can as the students. So were murdered at a home near campus in Moscow, Idaho. The tragedy garnered the attention of a worldwide audience on social media and the news media. The attracted audience frantically sought answers as it pertains to who committed the murders and the details of what happened that night. The police received thousands of tips from Good Samaritans trying to help solve the crime. Is that what Ashley is? A Good Samaritan? And here I thought she was a clout goblin. I'm glad I found out where that was from in the Logan Paul suing CoffeeZilla video, because I think that is actually where I first heard it, was in their beef from a year and a half that precipitated the current lawsuit. But if anyone is a clout goblin, Ashley Guillard is. Online sleuths and crime networks began their own investigations in an attempt to get answers. The demand for answers from the public increased as time went by with no arrest. On December 30th, 2022, Brian Koberger was arrested for the murder of the 4 students, and he had been under surveillance for almost a month before that. Like, a month and a half after the murders, he was arrested, but he was under surveillance for over a month as they were building the case. The public wasn't privy to that because you don't telegraph that you have someone under surveillance. Guillard's intuitive tarot readings. Guillard dedicated her life to spiritual development, growth, and mastery since 2016. She is motivated by purpose, not profit, as she said in her self-published book, Personification of Beauty, 2018. Purpose, not profit. Good Samaritan, not clout goblin. Ugh. During her spiritual journey, she developed claircognizant, also known as clairvoyant, abilities. Clairvoyance is the ability to perceive matters beyond the range of ordinary perception. And footnote 1 is the link to Merriam-Webster's dictionary definition for clairvoyance. The Department of Justice published Clairvoyance can offer information for assessment by law enforcement officials, and psychics and police work is that link. Since 2019, Guillard used her claircognizant abilities to get answers regarding the details of mysterious deaths, high-profile cases, and personal questions as requested. See Exhibit B, an excerpt from her unfinished yet self-published book, The Power of I Am, from 2019, detailing her development of claircognizance. Guillard shared the details of her tarot findings on social media, to include TikTok. Guillard routinely received confirming feedback regarding the accuracy of her intuitive tarot readings. See Docket 57, Exhibit A. And that's where she did a tarot reading for the wife of a military member and said, yeah, your husband's going to unalive himself. And he did like 7 months later. And it's like, yeah, that's not clairvoyance. That's recognizing that the military has a very high rate of people unaliving themselves. And it's that's what charlatans do. They are good at statistics, at reading the room, at, recognizing patterns. Had the guy not done it, she would have just said, oh yeah, he's going to, just wait. Just wait. Because I'm not wrong, I'm just early. So, but yeah, see Docket 57, Exhibit A, electronically stored information on YouTube, an intuitive tarot reading that accurately predicted the untimely death of Staff Sergeant Kenyon White. She naturally attracted an audience. Naturally. Guillard's involvement with the case of the murder of the 4 students. 2 weeks after the murders, of a concerned TikTok user asked Guillard to conduct a tarot reading to get details regarding the murder of the 4 students. She obliged. Guillard began the psychic investigation for no other reason than to find answers because she was asked. Her TikTok account was not monetized, nor did she receive payment for the videos posted on her TikTok. Guillard used her claircognizant abilities to gather all the pieces to the puzzle of what happened to the 4 students and why. She became very passionate and touched by their stories as told by the intuitive tarot readings and their social media footprint. An intuitive tarot reading revealed that Scofield would get away with murder if it wasn't for Guillard. At the time, Guillard did not know that would happen, but she decided to continue to seek the truth regarding the murder of the 4 students and to advocate on their behalf. A synopsis of the messages received from the tarot readings: the romantic relationship with one of the students. The tarot readings revealed that Professor Scofield hides that she is romantically interested in women because she is ashamed. However, her desire for the victim motivated her to take a risk and tell her she is interested in her romantically. She initially had a mentor-mentee type of relationship with the student. Scofield garnered the courage to tell the student about her feelings. The student was accepting of her and reciprocated the flirting. She then asked the student to experiment with her in a same-sex romantic relationship under the premise that she was gaining the confidence to be her true self. The student agreed. The relationship was a secret due to Professor Scofield being married and a professor for the University of Idaho. The student grew to love Professor Scofield. They spent time together and were romantically involved. However, as time progressed and the student neared graduation, she no longer accepted being in a secret relationship. She did not want to be second place to Professor Scofield's husband. She honored her values and self-worth. Instead, she wanted their relationship to be known. Professor Scofield misled the student. She never intended for the relationship to be public. Due to this disagreement, they broke up. Professor Scofield told the student that she was feeling neglected by her husband, and that is the real reason she initiated a relationship with the student. She then told her that she would not leave her husband because of their family. The student's heart was broken. She threatened to tell Professor Scofield's husband everything. It was an emotional break. Although the student was heartbroken, she got an amazing opportunity that diverted her attention. This is corroborated by Exhibit C, an article with the student's parents saying that she had a job lined up in Texas and a new car. She looked forward to her new life. However, in the background, Professor Scofield was excessively watching the student on social media and in person. She was extremely fearful that her secret relationship with the student would be exposed and that she would be embarrassed, lose respect, and possibly lose her job and marriage. Now, if you want to write erotic fan fiction such as this, just write erotic fan fiction. Do it about Twilight characters. 50 Shades of Grey. Seriously, if you want to write erotic fan fiction, don't do it about real people and claim it's true. Write it about Twilight. Write it about Harry Potter. Write it about, what's that Netflix show? Bridgerton. Write it about Bridgerton characters. Write it, since one of the mottos of this channel is that Rico is the legal equivalent of lupus. Write erotic fan fiction about House MD. I'm sure you can come up with great fan fiction about House and Wilson. Hell, I'm sure there's thousands of those out there already on the internet. Let me know if you've read any. Like before this, don't go out seeking it and then tell me you've read it. Just if you have previously, let me know. I won't kink shame much. But don't write it about real people. That's called defamation. Of course, I've never read 50 Shades of Grey. I'm under the impression it's not exceptional literature. I've never read Twilight. I'm under the impression it's also not exceptional literature. This is very unexceptional literature, but still, it's fiction. It's fiction. If you want to do this, write fiction. Try to sell it as fiction. Do dramatic readings of it on your TikTok as fiction. Literally, if it's how you get your rocks off, great, but do it as fiction. So, the murder plot and motives. After self-torturing herself with fear and anxiety of being exposed, Professor Scofield decided that she had to have the student killed to keep her secret safe. She later recognized that the student was surrounded by friends. See Exhibit D, the last photos of the student posted to her Instagram social media account that is captioned, "One lucky girl to be surrounded by these people every day." Professor Scofield's fear of being exposed, anger, and jealousy increased. She decided to include all of those around the student in the murder plot as well. All 6 students, to include the 4 victims and 2 others, who this is the first time I'm seeing their names in any of the litigation. I believe they lived in the house. But I'm not going to name them either, even though their names are in this legal document, because once again, they do not deserve to have their names plastered over this clown show, this circus. I really, really, really dislike Ashley Guillard for all of this. I mean, I'm entertained. Don't get me wrong. I'm entertained. But that doesn't mean this isn't all fucked up. Professor Scofield, and Professor Scofield doesn't deserve this either. Let's make that clear. Nor do her kids, her husband, her family, her friends, the University of Idaho. It's all Ashley Guillard's fault. All of it. Well, I mean, the murders aren't, but other than that. Scofield propositioned and manipulated the student's ex, the alleged hitman, to commit crimes. She promised him a better life experience, college life experience, and money in exchange for him to sacrifice his friend, the student. The hitman agreed. Like, how much money does this bozo think that a history professor makes? How much influence do they think a history professor makes? Yeah, get on my good, and you're going to the top. Like, history professors are important. I'm sure Professor Scofield is great at her job, very smart. You know, I believe her PhD is from Harvard. She's smart. But she's, you know, she's not a senator. She's not Clarence Thomas. She's a history professor. Well, how much influence does this moron think she has? How much money does she think she has? It's ridiculous. So the hitman helped Professor Scofield plan the murders, and he also monitored the student and her friends. He informed Professor Scofield that the student was in town the weekend of November 11th, 2022. Professor Scofield insisted that the murders had to occur that weekend, the evening of November 12th, 2022. the hitman initiated the plan. The evening of the murders, the hitman procrastinated. He took some time to think, to make sure he wanted to go through with the plan. He played with the dog he shared with the student, and he ignored Professor Scofield's attempts to contact him. Professor Scofield panicked. She thought the hitman was deceiving her instead of the student, or that the task was too big for him. Therefore, she initiated another plan. She contacted Brian Koberger on an impulse, recruited him for the job to kill the student specifically, and sent him to the victim's residence on King Road. She ordered him to check for activity and to see if the hitman was committing the crimes before doing anything. This is supported by Exhibit E, page 6 of the probable cause affidavit used to arrest Koberger, which alleges that Koberger drove by a few times before entering the home. You know what isn't in the probable cause statement? Contact between Brian Koberger and Professor Scofield. Like, they've dumped his phone. They have his phone. What? Why do they not have evidence of this? Were they using mind powers to communicate? Were they using telekinesis? What? I mean, funny how Ashley Guillard only brings Brian Koberger into this because he was charged, because there's evidence, because the police did an investigation. You want to impress me? Tell me about this on November 13th, 2022. Tell me about it before it's in the media. Here, this is self-serving BS. She's trying to pound a round peg into a squiggly hole. Not going to work. It can't work. It's ridiculous. And riddle me this. How? Like, that night, according to Ashley Guillard's fan fiction, it was that night when the hitman was procrastinating that Professor Scofield got worried, and that's when she contacted Brian Koberger on impulse and recruited him as the backup hitman. Did she Google Hitman R Us? The Hitman Exchange? The Hitman Warehouse? Like, I realize Moscow and Pullman are basically sister cities, you know, either side of the border. Pullman, Washington. I think it's in Pullman. What kind of Pac-12, you know, rest in peace, Pac-12, but what kind of Pac-12 fan am I? Yeah, it's Pullman, Washington, Corvallis, Oregon, because Washington State is in Pullman, Washington. Oregon State is in Corvallis, Oregon. That's where they are. But they're basically on either side of the border. So, yeah. But different universities. She's a history professor. He's a criminology PhD student. Like, what? How? Does she just reach out to a random profile at university at Washington State University and say, "Hey, if you've ever wanted to be a hitman, tonight's your night. Boy, are you in luck." Like, is she spontaneously recruiting a stranger from a different university? Yes, a different state, but like they literally might be closer than I am to the next neighborhood here in Salt Lake City. Maybe not to the nearest city, because frankly, Salt Lake City is weird, and in that it's a very small capital city in a, yeah, frankly, we should have annexed unincorporated land long ago, but that's neither here nor there. Either way, Mill Creek is a lot closer than you'd think it is. You'd think it's all the same city, but either way, it doesn't make sense. It really doesn't make any sense that she recruits a backup hitman from a different university that there's no obvious ties to how she'd know of him. Like, literally, to even know of him, let alone know he's willing to be a hitman at short notice. You hire me to be a hitman, you need to hire me a lot sooner than the night of. I need to plan that shit. I'm not going to be a hitman. You hire me to be a lawyer to defend a hitman. You need to hire me before the morning of trial. I need time to plan that shit. When Koberger arrived to the residence, the hitman was already there executing the plan to murder the students. He refused to have Koberger involved. Sacrificing the student was a big deal to him. He refused to split the money he was promised with Koberger because if he received anything less from the deal, it would no longer be worth the sacrifice. Scofield and the hitman communicated. They argued to his lack of communication with her. Additionally, she wanted Koberger to help the hitman and for them to share the profit. She thought it was more than enough money to go around. The hitman refused to accept the help. Koberger decided to leave instead. This is supported by by the other roommates. So the additional intended victim who was not killed. So supported by their witness statements that she saw a masked man walk past her and towards the black backsliding door. Koberger decided to leave instead. This is supported by the witness statement that she saw a masked man walk past her towards the backsliding door. That's not supportive of Koberger leaving after an argument and like Koberger was not there when police arrived. Therefore, one would surmise that if he is indeed the killer, at some point he left. So him leaving does not in any way, shape, or form support Ashley Guillard's fan fiction. This is ludicrous. It is also supported by footage of Koberger's alleged vehicle leaving the King Road neighborhood at 4:20 a.m. See Exhibit E, page 4 and page 6 of the probable cause affidavit. So, but there's footage of Koberger's vehicle leaving the King Road neighborhood. Is there not video surveillance of the hitman arriving or leaving, or like it's 4:20, so maybe he's in the passenger seat of Koberger's car, 420ing. Is there no video evidence of that? Of course, is there only one exit from the neighborhood? I don't know. I absolutely hate neighborhoods that do have limited entrances. Subdivisions are an abomination like that. I like Salt Lake's grid. There are problems with that too, but it's so much better than Subdivisions. Although Subdivisions is a great song by Rush. Might be my favorite of their songs. Just love that booming bass synthesizer to open the song. Like, I'm terrible on piano, but I want to get an Oberheim OBX keyboard synthesizer just because of that song. So if anyone wants to send me one, they're only a, couple $1,000, it's worth it. They're vintage 80s synthesizers. They're cool. So the original plan Scofield had with the hitman continued. She noted that Koberger was now a problem that needed to be fixed in the future. The hitman increased his communication with Professor Scofield, showing her proof of the crimes being committed. Ashley Guillard, okay, saving our place, we're on page 6. But remember, all the way up here in the introduction, the burden of proof in defamation cases rests on the plaintiff. Scofield has not proven the statements Guillard made about her are false. Therefore, as it stands, the statements are legally presumed to be true, which is false. That is not the standard. But what for all of this nonsense, for showing her proof or increased communication, where's the proof? Where's the proof? These are all just allegations, no evidence. It's nonsense. It's bad fan fiction. The murders were not done quickly. It was what seemed to be a night filled with chaos and drama. The hitman came to the residence. Together, they all consumed drugs and alcohol that the hitman paid for. The students had no idea that he was there to murder them. The hitman supplied the libations with the expectation to be paid for sex, to be paid with sex from the student. After the student refused to have sex with him, the hitman became very angry and belligerent, pretending to be lonely, cheated on, deceived, and used for drugs. But it was all a ploy. If you're like seriously though, if you're going to murder all of them, why even put on the act? Seriously, this is stupid. This is stupid. This is middle school fan fiction at best. It's stupid. Like, why does he need to set up this motivation, essentially? If you're gonna kill them all, what does it matter? They can't testify against you. They're dead. This is stupid. After this went on for a while, a couple of the girls began to have sex with him to calm him down and to pay the debt. One of the students was very uncomfortable with the situation. He attempted to stop the girls from being forced into sex. One of the girls joined him in the opposition. There was a physical altercation, and the male protester got the best of the hitman. The situation calmed for a while as the hitman pretended to be emotional and heartbroken over the student. The protester was not buying the act. The hitman story did not make sense to the protester, but the women showed him empathy. They believed him. So, physical altercation. Where's the evidence? I mean, I realize, yeah, it's a murder scene, 4 murders, quadruple homicide. But if there's a physical altercation, like literally, I don't know if, especially the male victims, if they were attacked in their sleep, if they were awake, if they put up a fight. I don't actually know. But if there's a physical scuffle, where's the evidence? Like, you'd think the hitman would leave fingerprints, leave DNA. He would have had defensive wounds. Like, he was seen in public after the murders because, he wasn't a suspect or anything, so he wasn't in hiding. Like, there's no evidence of this. Forced into sex. Where's the evidence? Like, seriously, to my knowledge, I at least haven't seen evidence that any of the victims were forced into sex. Is there penetration wounds? Is there biological fluids? Where's the evidence? Literally, all of this will leave evidence, but there's none. There's none. And like, so he's wearing gloves and a mask and like protective equipment, but acting all cool to not be suspicious so that his murder victims couldn't testify against him. But even though he's acting all cool and nonchalant and, you know, here, take my drugs and alcohol. We're all friends. Nothing suspicious here other than my gloves and mask and, you know, where does any of this make any sense? Where does the lack of evidence of any of this make any sense? I mean, the police were so thorough that, you know, they found trace amounts of DNA on a knife sheath, but all of this fan fiction sounds like it would leave a lot of physical evidence. Where is it? Where? It doesn't exist because this is fan fiction and it's disgusting. Ashley Guillard is disgusting. But Joe, tell us how you really feel. Sometime later, the Koberger incident happened, after which the hitman was motivated to finish the crime. He began acting belligerent again. The protester confronted the hitman again to protect the girls, but he was brutally attacked instead. The protester was the first to be stabbed. The female protester stayed with the protester, attempting to help him. She feared she was being watched. She hoped to be rescued. She thought the surviving roommates were going to get help. This is supported by the probable cause affidavit, Exhibit E, page 4, where the non-victim stated she heard crying from the female protester's room, and she heard someone tell her that they would get help. No one helped. The surviving roommates hid to protect themselves. The female protester did not want to call the police unless she had no other choice. She decided to face her fears and to help herself and the girls, but she did not know her footing nor the magnitude of the danger she was facing. Fuck me sideways, this woman is insane. She's stupid. She thinks we're all stupid. She thinks the judge is stupid. She, according to Ashley Guillard, she saw one of her roommates, the male, murdered, tried to intervene, but she didn't want to call the cops unless it was really necessary. Is she stupid? That's rhetorical. But I just saw someone murdered, but I'm going to wait it out, and because, I don't want to bother the police if I don't really have to. It's only if it becomes really necessary. If there's a knife in my back, then maybe I'll call the police. Maybe. 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 It's like, I mean, maybe she couldn't call the police. Maybe she couldn't, but not wanting to unless she had no other choice. Like, if I'm a publisher and I get sent this fan fiction, I'm turning it away because it's not believable. It's not believable. It's insulting the intelligence of the reader. So she went to the room the other girls were in and found them brutally murdered. The killer was there, grieving. According to the reading, that killer is the hitman. He brought the final victim back to her room. She pleaded with him for her life. He vented to her before she was killed. Exhausted, he looked quickly for the other roommates and then left. She was the last to be killed. The surviving roommates heard everything, but did nothing to stop it. They remained hidden as a self-preservation tactic. None of them called the police because of a youthful lack of judgment, misplaced trust, paralysis due to fear of being watched, to avoid being judged, and to avoid trouble for breaking the rules. They wanted to solve the problem themselves. The victims did not know the magnitude of the danger they were in. Fuck you, Ashley. Seriously, fuck you. Procedural history and harassment. To discredit Guillard, her reputation, character, account of events, and legitimacy, on December 21st, 2022, Professor Scofield fraudulently filed a 2-count defamation complaint against Ashley Guillard. The complaint was completely fabricated and filed with the intent to harass and take revenge against Guillard for exposing Professor Scofield's affair with the student and her role in the murder of the 4 students. In nearly all their dockets within the complaint, Professor Scofield and her attorneys made false statements of fact about Guillard's character, mocked and degraded Guillard's spiritual practice, and misled the court regarding the nature of the complaint. Within a week of the filing of the complaint, Professor Scofield and her attorney, Wendy Olson, started a smear campaign against Guillard, using the news media to embarrass Guillard, to spread lies about her, and to annihilate her character. They told the news media that Guillard intentionally fabricated lies about Scofield's involvement in the murder of the 4 students for self-promotion and to profit from the tragedy. That was a lie. The truth is, Guillard used her keen claircognizant abilities to get truthful answers on what caused the murder of the 4 students. She posted TikTok videos to promulgate the truth and to seek justice. Her TikTok account was not monetized. She did not profit from the videos about the 4 students or any other video on her TikTok account. They told the news media that Guillard re-victimized the families of the victims. That was a lie. The truth is, she was attempting to help get justice for the victims. Now, whether Guillard profited or not is irrelevant, frankly. It's completely irrelevant. You don't have to have profited off of your defamatory statements to be liable for the defamation. It doesn't matter. Now, Guillard, though, whether she profited directly from videos or not, doesn't mean she didn't profit off of the videos. If she charges for tarot readings, like, let's say the dead soldier who Ashley Guillard did the tarot reading for. Did she charge? Does she charge for tarot readings? Does she charge for her book? Well, books. She listed 2 of them. If so, the clout she gains as a clout goblin off of the TikToks may be indirect, but it's at least an attempt at profit. Now, I don't actually know exactly how to get monetized on TikTok. I'm certainly not monetized on TikTok. I doubt I will become monetized on TikTok. But even if she wasn't monetized when she was doing this, was she doing the videos in hopes of monetizing her TikTok in the future? I mean, when I live streamed the Daryl Brooks trial, I streamed every minute of that trial. I didn't make a penny on it. I wasn't monetized yet. Was I streaming it in the hopes of future monetization? You bet your ass I was. Absolutely. So, did I profit off of streaming the Daryl Brooks trial? No, not directly. Did I indirectly? Probably. I probably got monetized sooner than I otherwise would have by live streaming the Daryl Brooks trial. So, like, even if she didn't directly receive monetary gain, profit, doesn't mean that wasn't her motivation, or at least one of them. Clout is its own motivation. To a clout goblin, the notoriety might be more important than the profit. So, Professor Scofield and attorney Wendy Olson's egregious false statements of fact about Guillard were massively published in multinational news media outlets and multinational social media channels to multi-millions of viewers. The lies were accepted as true and caused Guillard to be harassed on social media, her website, on book reviews, telephonically, and by email. What the fuck do you think accusing someone of murder does? Seriously. Oh, they told lies about me and it caused me to get bad reviews and emails. And now you know what Professor Scofield had from the nut jobs that believed you. She was harassed. She feared for her safety. She didn't choose any of this. You did. You clout goblin monster. Fuck out of here. Guillard's spiritual practice and personal reputation was ruined. Her TikTok page was continuously targeted by fake social media accounts and Scofield supporters. Guillard TikTok page was ultimately banned from TikTok due to Scofield and her attorney's false allegations against her, and due to the near continuous false reporting of community guideline violations on her posts. Knowing the complaint and their subsequent dockets were completely fabricated, and that Scofield did not suffer any damages from Guillard's tarot reading, Scofield and her attorneys abused the judicial system by seeking multi-million-dollar judgments against Guillard. They continued to use the judicial system to harass Guillard from December 21st, 2022 to the date of this filing, February 2nd, 2024. Good God, we're behind. Outside of court, Professor Scofield and her continuously harassed Guillard on social media through the creation of newly created fake TikTok and YouTube accounts used to threaten her life, make false statements about her mental health, and to threaten a hate crime against her. This is all well and good, but how does this go to summary judgment? And as I always say, this is not a petting zoo. This is an animal safari. Keep your arms and legs inside the car at all times. Do not approach the animals. Do not interact with the animals. Do not contact Ashley Guillard. Do not email her. Do not telephone her. Do not comment on her videos. Don't give her the clout. But do not harass her. She's not worth it. You're better than that. I know my viewers are, at least. Professor Scofield's supporters also routinely called Guillard's personal cell phone several times, referring to Professor Scofield as an innocent professor, asking Guillard who is the real killer, even calling on Christmas Day. The calls increase when Guillard. In fact, as Guillard wrote this response, she received several harassing phone calls to her personal cell phone number from a Scofield supporter with a made-up phone number asking, "Are you the killer?" See Exhibit F, a YouTube video, a few incidents of telephonic harassment. See also Exhibit H with a YouTube link. Legal standards and argument. Finally, the merits of why summary judgment is not appropriate here. I mean, it totally is, but tell us why it isn't. Preferably, show us, let's look at it again, get the exact language. So, the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. So basically, the movement is entitled to judgment as a matter of law. Basically, what that means is, hey, there has to be a valid cause of action. Here it's defamation. If there's no disputes as to material facts, but no valid cause of action, no recognized cause of action, you can't get summary judgment because, all the facts you gave are true, but they don't support a valid cause of action. So summary judgment on what? But here it's defamation, valid cause of action. And so basically you have to show us any element of defamation where there's a factual dispute, where there is a genuine dispute as to material fact. And it has to be a material fact. It can't. I have a feeling, though, as you know, I don't read these ahead of time. Otherwise, it's not a reaction. But I have a feeling she's not going to provide us actual disputes as to material fact. Although she is actually, from the headlines at least, trying to. So, legal arguments, legal standards and argument. Notwithstanding the fact that the plaintiff's entire complaint is completely fabricated and fraudulently filed, it does not meet the criteria for a summary judgment favorable to the plaintiff under Rule 56. There are several genuine issues of material fact. Additionally, the plaintiff is not entitled to judgment as a matter of law because she does not have a valid defamation claim. She does. She does. Because saying someone murdered someone, if it's not true, is defamation. That's a valid defamation claim. Saying someone engaged in an affair that would both damage her marriage and her job, is defamation, a valid defamation claim, assuming it's, assuming the falsity of the claim. So basically she's trying to say this isn't a valid cause of action even if everything was true. But that's ridiculous. As a matter of law, that's ridiculous. Because defamation is a valid claim. So there are several genuine disputes regarding material facts. Scofield fails to meet the criteria established by Rule 56A. I have a feeling we're not going to see evidence for any of these disputed facts. Remember, we looked at, right here, the amended statement of undisputed material facts. This is what the motion for summary judgment is supported by. And it includes admissions from Ashley Guillard. It includes evidence provided by the University of Idaho, official records that none of the students were in Professor Scofield's class. It includes sworn declarations by Professor Scofield. Ashley's not going to have any of that. So, pursuant to Rule 56 of the Federal Rules of Civil Procedure, in order to succeed in a motion for summary judgment, the movement must show, 1, that there is no genuine dispute as to any material fact. Guillard has consistently persisted that the statements she made regarding Scofield's role in the murder of the 4 University of Idaho students are substantially true. In this civil defamation case, Professor Scofield has the burden of proving that she did not have an affair with the student and that she did not order the murder of the 4 students. See Gertz versus Robert Welch, Supreme Court, 1974. And here, Professor Scofield has provided evidence, her sworn statements. Ashley Guillard has not. She's made assertions, but they're unfounded. She doesn't have any support. And she's trying to say, well, I disagree with these. Therefore, there is a dispute as to the material facts. But just saying, I don't agree with that fact, doesn't mean it's not disputed. Doesn't mean, because once again, no genuine dispute as to any material fact. Just saying, I don't agree with that, doesn't make it a genuine dispute. You have to bring some evidence to dispute the fact. You have to bring, a picture of Professor Scofield and the students together. You have to bring a sworn statement from the hitman. You have to bring something. Just saying, yeah, my tarot cards said it. That's not a genuine dispute as to the material facts. It can't be. Why am I getting Los Angeles and Houston? Like, all the other lawyers advertised here makes sense. But why am I getting a Houston-based asbestos and mesothelioma attorney and a Los Angeles-based tax attorney? Like, all the others make sense. Cornell Law School, your cookies are not very good. Although I have a feeling I know why the tax law one is, but you'd think a Utah-based tax law attorney would show up. Just doesn't make sense. Even doing recording videos, I'm still going to chase squirrels. It's just chat's not going to send me chasing the squirrels. So, quote from Gertz versus Welch: allowance of the defense of truth with the burden of proving it on the defendant does not mean that only false speech will be deterred. But as a defense, the burden of proving truth as a defense is on the defendant. The First Amendment requires that we protect some falsehood in order to protect speech that matters. Therefore, the legal assumption as required by First Amendment is that Guillard's ideas are not false unless otherwise proven. We begin with the common ground. Under the First Amendment, there is no such thing as a false idea. However pernicious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. And that's Gertz versus Welch still. But once again, Guillard has not provided anything. Nothing. Not a single bit of evidence to prove the truth of her statements as a defense. So even assuming this is a real case being accurately cited, I don't have confidence that she hasn't been using ChatGPT and getting AI-derived cases. But here, the competition of ideas, of other ideas, you have to bring something. The falsity of Guillard's statements have not been proven. Therefore, the default position is that Guillard's ideas about Professor Scofield's affair with the student and Professor Scofield's role in the murder of the students are presumably true. That is false. False. Show me a citation that it's presumably true. It's not. No citation here, because that citation doesn't exist, because this is made up. This is a misstatement of the law. This is legal fiction. It's bullshit. Pursuant to Rule 56C1B, a party asserting that a fact is genuinely disputed must support the assertion by showing that the materials cited do not establish the absence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. Professor Scofield's argument for a summary judgment is frivolously supported by Guillard's admissions. Frivolously supported by the defendant's admissions. My head is going to explode. My head is going to explode. Frivolously supported by the defendant's admissions. Procedures. We're looking Rule 56C of the Federal Rules of Civil Procedure, supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by A, citing to particular fact or particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, including those made for purposes of the motion only, admissions, interrogatory answers, or other materials. Ashley Guillard says, let's go back. Let's go back. Professor Scofield's argument for summary judgment is frivolously supported by Ashley Guillard's admissions. A party asserting that a fact cannot be genuinely disputed must support that assertion by citing to particular parts of materials in the record, including admissions. How is it frivolous that Professor Scofield is following the rules of civil procedure? How? She broke me. She finally broke me. Professor Scofield is cheating by following the rules of civil procedure. It's unfair that you're following the rules of civil procedure. How dare you? That's frivolous. What is this bitch smoking, and where can I get some? I'm sure it's legal because it's some new drug only available to Ashley Guillard. And it must be good stuff, because if you can say that with a straight face, she's frivolously following the rules of this proceeding. Therefore, she's cheating. If you can say that with a straight face, you're on good stuff. I mean, she has said some monumentally stupid things throughout this litigation. Monumentally stupid. But this might just take the cake. It's not just taking the cake, it's taking the whole damned bakery. No one else gets any cake. Ever. She took all the cakes from the entire bakery and then burnt that bitch to the ground because only she gets the cake. But Scofield's argument for a summary judgment is frivolously supported by Guillard's admissions, the TikTok videos Guillard published, so documents, electronically stored information, other materials. So the videos are evidence. They're electronically stored information. They're kind of documents. They're videos, but the rules of civil procedure were written pre-YouTube. I mean, they are regularly amended slightly, but yeah. So videos and a false declaration from Scofield, from Professor Scofield. Hey, look at this. Affidavits or declarations. So Professor Scofield's declaration somehow, even though it's in the rules, as are Ashley Guillard's admissions, it's frivolous of Professor Scofield to rely on the allowed admissions and the allowed declaration if Ashley Guillard were to publish this as a fan fiction, it would be titled Harry Potter and the Audacity of This Bitch. Sadly, I can't claim credit for that, but I think it's fitting here. First, wrong. Those of you who watch Law Talk with Mike will know what I'm talking about there. But first, Guillard's admissions established that she used her claircognizant abilities to get information regarding the murder of the 4 students and Professor Scofield's role in the murders. Guillard's admissions do not support Professor Scofield's burden to prove that Guillard's ideas are false. Except the admissions say that you have no physical evidence, you have no written evidence, you have no evidence provided to you from any living person. Second, Guillard's TikTok videos established that she promulgated her ideas regarding Professor Scofield's affair with the students and Professor Scofield's role in the murder of the 4 students. Guillard's TikTok videos do not support Professor Scofield's burden to prove that Guillard's ideas are false. I just can't. I just can't. The videos can only be used in the summary judgment motion if they're used to prove that the videos are false. No, they're proving defamation, and publication is an element of defamation. In order for you to have defamed someone, it has to be published. Now, if it's a video or in writing or whatever, it has to be published. It has to be made so that other people can see it, posted online, plastered onto lamp posts, emailed to people. If it's spoken, it has to be spoken to another person. That's publication. This entire litigation is about the TikTok videos. Professor Scofield isn't using the TikTok videos to prove the falsity of the TikTok videos. The existence and a publication of the TikTok videos is an element of the defamation. Lastly, Professor Scofield's declaration establishes that she denies having an affair with the student and denies that she was involved in the murder of the 4 students. Professor Scofield's declaration do not support the plaintiff's burden to prove that Guillard's ideas are false by a preponderance of the evidence or with convincing clarity. What the fuck is convincing clarity? Like clear and convincing standard? Convincing clarity? Here, Professor Scofield doing a declaration. That's evidence. It's a sworn statement. That's evidence saying, yeah, I never murdered anyone. I've never had an affair. I didn't know any of these students. I've never met them. They've never been in my house. I didn't hire a hitman to kill any of them. I had no reason to do any of that. This is all made up. See, we take that and then we take Ashley Guillard's declaration, if she even has one. I don't know that she has. I think she's relied on her pleadings, which unsupported by a declaration. They're just the ramblings of a madwoman. But her declaration would be like, but my tarot cards said you did, therefore you did. And then the finder of fact will say, so we have this evidence of the person saying they didn't do it, and that we have this evidence of the person saying, well, I didn't see her do it. No one's told me she did it. I don't have any physical evidence. I don't have any written evidence. Just my tarot cards. And so you take those and you say, yeah, so this one is the actual evidence, and I'm going to believe that. I'm going to believe that because you don't have anything, even though it's just Professor Scofield's sworn statement, her declaration. It's an actual timeline of what Professor Scofield did and didn't do. You see the difference there? I know Ashley doesn't, but she's dumb. In a civil case, the plaintiff must convince the jury by a preponderance of the evidence, i.e., that it is more likely than not that the defendant is responsible for the harm the plaintiff has suffered. And we have footnote 3, which is uscourts.gov/about federal courts, types of cases, civil cases, That's not a great citation, especially as presented. And this is just terrible legal formatting, but I'm not going to get into that. So Scofield's word does not amount to a preponderance of the evidence. It is illogical to expect someone who is willing to kill to keep her secret safe to in turn admit to quadruple murders and an affair with a female student. It's illogical to take the word of someone that just says, I wasn't there, but trust me, bro. Like, literally, it would be illogical to take the word just, yeah, I didn't do it, versus saw her do it. I pleaded with her not to. I barely escaped with my life. You know, if Ashley Guillard came with that, I'm not saying we should believe her, but it's at least something. Here we literally do not have anything from her except, trust me, bro, she really did it. I don't have any evidence whatsoever. But since she can't prove the negative, she really did it. That's what Ashley Guillard is doing here, and it's offensive, and it's she must lose. She has to. Spoiler alert, she does, but we'll get to that in a future video. Additionally, during the entire litigation and in every docket, Professor Scofield and her attorneys have continuously misled the court and the public by spreading the false narrative that Guillard intentionally lied to gain a profit from the tragedy. They also fabricated nearly $2 million in damages, despite Professor Scofield having no actual damages. That's why they're going to have a trial. That's why they're going to have a trial. Because in defamation cases, it's hard to decide what the actual damages are. She's clearly been damaged, but what's the right way to compensate her? They're going with, or at least attempting, like the Cardi B damages model. They cited that in their request way back. But let's see. Way back. So clerk's entry of default, motion for default judgment is memorandum in support. That's what we'll look at. So this is from all the way back in February of 2023 in the motion for default judgment. This was before the default was set aside because Ashley Guillard said, I promise I'll follow the rules, but I'll accuse the plaintiffs of frivolously following the rules. But this is where they asked for at least $1.863 million in damages, and that's based on several things. It's, 10 years worth of Professor Scofield's salary since the false allegations put her job at risk, and other damages, and they jeopardized her ability to collaborate with co-authors, jeopardized her ability to perform her studies, which require working with LGBTQ plus populations, because she's a history professor, but her specialty is history of LGBTQ plus issues. And so here, so Professor Scofield is unaware of a factual analogous case that has gone to verdict, but she is aware of Almanzar versus Kebby, a recent case. A jury awarded the plaintiff $1 million as compensation for pain and suffering and $4,088,753 total after the defendant posted YouTube videos and Facebook posts that made false statements that the plaintiff had a sexually transmitted disease, committed infidelity, was a prostitute, and took drugs. So Almanzar versus Kebby was the Cardi B, Tasha K case where Cardi B received over $4 million in damages from Tasha K. For coverage of that, see Emily Baker. She did full coverage of that case several years ago. So it's not that they fabricated $2 million in damages, going back to the motion we're discussing today. It's they used a formula to try to come up with an amount in damages. It might be 2 million, it might be more, it might be less, but that's for the side. This was when they were asking the judge to grant it way back because, as a default judgment. But here, as we mentioned, they're going to have a jury trial just to determine the amount of damages. Could be a lot more, especially, the 1.8 million roughly that they asked for. It didn't include punitive damages because at that point they weren't allowed to ask for punitive damages yet. Here, they're asking for punitives now. Remember, they amended the complaint right before this to ask for punitives. The upper limit of punitives is, depending on state, there are some states where it's limited, but the upper constitutional limit, according to the Supreme Court, is roughly 10 times the compensatory damages. So let's say the jury awards 1.8 million in compensatory. They could, give 5, 10, 18 million in punitive. Maybe. Of course, looking back at the Depp v. Heard, the jury awarded Johnny $10 million in compensatory and $5 million in punitive. Of course, the jury didn't know that Virginia state law limited punitive damages to $350,000. So even though the jury awarded Johnny $15 million total, Johnny was only by law allowed to try to collect $10,350,000. Of course, they ended up settling down the line, but yeah. So they made those false statements under oath with the intent to mislead the court and the public. Guillard is the only party that has consistently upheld her ideas and integrity the entire litigation. Therefore, Professor Scofield's word does not prove anything except that she is willing to lie and perjure the court to get her way. Truth is a valid defense for defamation and is still being disputed. Ergo, Professor Scofield fails to meet the criteria for a summary judgment under Rule 56A. Thus, the plaintiff's motion for a summary judgment must fail. What did I tell you? She didn't bring any disputed facts. She didn't say, hey, so this fact, here's the evidence in the record that disputes it. Therefore, not all the claims are undisputed. Not all the elements are undisputed. There's disputed facts that the plaintiff relies on that if they're disputed, not taken as true, summary judgment fails. Therefore, there's a triable issue of fact. Here, it was just, nuh-uh, I've told the truth. She hasn't. Therefore, no summary judgment. She didn't bring anything. So, next up, Scofield is not entitled to judgment as a matter of law. Scofield fails to meet the criteria of Rule 50A and Rule 56A. So let's take a look at Rule 50, and that is judgment as a matter of law. So in general, for judgment as a matter of law, if a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for the party on that issue, the court may resolve the issue against the party and grant a motion for judgment as a matter of law. Here, I mean, seriously, why are we even discussing Rule 50A? Why are we discussing judgment as a matter of law? Because let's take a peek at, motion for summary judgment pursuant to Rule 56 and Local Rule 7.1b. Let's look at the memorandum in support. I mean, she says judgment as a matter of law. But I'm going to give Ashley Guillard the benefit of the doubt here. Well, frankly, I didn't need to do a search because Wendy Olson, Professor Scofield's wonderful attorney, provided the table of contents with a table of the rules used. 56, 56A, Rule of Evidence 801A, Rule 36A, that'll be discovery stuff. In fact, let's tell you what Rule 36 is. Request for admission. But attorneys sometimes use summary judgment and judgment as a matter of law as synonyms, but they're not necessarily. Because here, this entire motion was a motion for summary judgment. But to Ashley Guillard's credit, she wouldn't understand this because she's not a lawyer. So Professor Scofield's attorneys did say judgment as a matter of law, but they used it in discussing Rule 56 and summary judgment. They never brought up Rule 50, but Ashley Guillard sees judgment as a matter of law, sees Rule 50, judgment as a matter of law, and is arguing against judgment as a matter of law, even though she only needs to argue against summary judgment. because here, I'm sure you all, legal scholars that you are, at least regular followers, will have caught why this isn't relevant, Rule 50. Why Professor Scofield isn't arguing it. And it's because if a party has been fully heard on an issue during a jury trial, they haven't been fully heard on this issue at a jury trial. So Rule 50 doesn't exist, at least not yet. This is, I've referred to this before as the Pink Floyd motion. In the song At the End of the Wall album, The Trial, the judge booms out, "The evidence before the court is incontrovertible. There's no need for the jury to retire." So basically Pink Floyd was describing this. The evidence before the court is incontrovertible. There's no need for the jury to retire. Now, of course, they were a little bit wrong, Pink Floyd, because it was finding the defendant guilty. No need for the jury to retire. Here, what would happen is, after Professor Scofield finished presenting her case to the jury, but before Ashley Guillard presented her defense before her case in chief, she'd get up has not proved her case. She's missing this element. She forgot to identify the defendant. Therefore, I win. You must dismiss. We saw the criminal equivalent of this motion in the Karen Reed trial. Remember, when the prosecution rested, but before presented its case, little Alan Jackson jumped to his lifted feet, and before the jury could even scurry out of the courtroom, he tried to get it in front of the jury, which the judge rightfully made him wait because it's inappropriate to argue that in front of the jury. But he argued, "Your Honor, for these reasons, they haven't proved the case and you must dismiss." And the judge said, "No, no, 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 no." So basically, Ashley Guillard is arguing that against that, but it's not a trial yet, so this doesn't apply. Now, of course, it doesn't, because this is civil. Because this is civil, if a party, it doesn't say if the state, if the defense, if the plaintiff, if the defendant, it says if a party has been fully heard. So after the defendant has presented her case, if it goes to trial, Ashley Guillard can present her case, and Professor Scofield could get up and say, "Your Honor, a jury would not have a legally sufficient evidentiary basis to find for the defense. You must find for me that blah, 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 that I was." Now, chances are the judge is going to let the jury debate. If, though, the jury comes back with a verdict that's fully unsupported by the evidence, you can bring one, and the judge can bring it. It's It's called a judgment notwithstanding the verdict, JNOV. And yeah. But either way, none of that is relevant here other than that Ashley Guillard is arguing it. So the plaintiff erroneously claims that Guillard has admitted to defamation as a matter of law. See docket 63. That's the summary judgment motion. But she has. We looked through the admissions. She made the statements and she admitted to them. She admitted she has no evidence to back up the statements. She admitted she is a witness. She admitted she has not heard from any living person. She has no writing. She literally only has her tarot readings. So, pursuant to Rule 56A of the Federal Rules of Civil Procedure, in order to succeed in a motion for summary judgment, the movement must show, too, that the movement is entitled to judgment as a matter of law. Here, I guess I'm not giving Ashley Guillard the benefit of the doubt. Because she saw in Rule 56 where it says judgment as a matter of law, and then she sees, Rule 50 is about judgment as a matter of law. Therefore, she has to satisfy Rule 50 as well as Rule 56 in order to, but Rule 56 doesn't refer to Rule 50. It doesn't mean you have to have the opportunity and, have your case before a jury, blah, blah, blah. Otherwise, why would you have summary judgment that's available at any time? Literally. Let's go back to summary judgment. Time to file a motion. So 56B. Unless a different time is set by local rule or the court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. So, by Ashley Guillard's bastardization of the Federal Rules of Civil Procedure, you can never file a summary judgment motion. Literally, you cannot. Because if you have to use the rules of Rule 50, that means at least one side has already presented their entire case in chief in a trial. So by Ashley Guillard's rules, you can only bring a summary judgment motion after the plaintiff has rested their case, and that's when the defense can bring the summary judgment motion. Otherwise, the plaintiff can only bring it after the defense has finished its case in chief. So even though at any time, unless a different time is set by local rule or the court orders, but like I said, if you have to incorporate judgment as a matter of law, because that's, no genuine issues of material fact, and the plaintiff and the movement is entitled to judgment as a matter of law, are the standard for summary judgment. But if for the second element for summary judgment, you have to go judgment as a matter of law, the opposing party has to have been fully heard on the issue during a jury trial. Now, So let's see. Okay. Rule 26D, timing and sequence of discovery. A party may not seek discovery from any source before the parties have conferred as required by Rule 26F, except in a proceeding exempted from initial disclosure under Rule 26A1B, or when authorized by these rules by stipulation or by court order. Time to deliver more than 21 days after the summons of the complaint. Request under Rule 34 may be delivered to the party, blah, blah, blah. So you can tell I'm a criminal defense lawyer. Because I know the federal rules of civil procedure pretty well, but I can't remember all the deadlines. Either way, there's discovery closes. And let's just look in the docket. Let's see. Well, no. Well, scheduling conference. So they're on the expedited track. Cases on this track will typically be set for trial approximately 9 to 12 months following the case management conference, take 4 days or less to try, and involve limited discovery. Dispositive motions, filing cutoff date, January 12th. This cutoff date should be set within 3 to 6 months following the case management conference. Discovery plan. So factual discovery cutoff date 12 to 15 or 12/15/2023, 15 to 30 days prior to the dispositive motion cutoff. Counsel may, however, stipulate blah, blah, blah. So either way, you know, the factual discovery cutoff date, December 15th. The dispositive motion cutoff date was December 12th, or January 12th, which was when this was filed. But according to Ashley Guillard, you couldn't actually file it until after the trial, which hasn't happened yet. 6 months later, 7 months later. Therefore, it's after the dispositive motion cutoff date. You can't. You literally can't. Therefore, Rule 56, according to Ashley Guillard's reading, is moot. It does not exist. It's inoperable. It can't function because the only time you're allowed to bring it according to Rule 50 is after you're allowed to bring it according to Rule 56. Therefore, it's inoperable. It does not work. But in Ashley Guillard's world, that's how it works. Luckily for us, we don't live in her world. So, B requires that the court may grant a motion for judgment as a matter of law against the party on a claim or defense that, under the controlling law, can be maintained or defeated only with a favorable finding on that issue. For a defamation claim to be valid, include defamation per se, the statements made must be false. Once again, Rule 50, that we're not discussing Rule 50. We're not discussing it. That there was no, I mean, here, Rule 50A1B requires that the court may grant a motion for judgment as a matter of law. There is no motion for judgment as a matter of law. There's a motion for summary judgment, for partial summary judgment, I should say. But the elements of a defamation claim applicable here are as follows. The plaintiff must prove that the defendant, 1, communicated information about her to others, 2, the information was defamatory, and 3, she was damaged because of the communication. Here it's defamation per se, so you don't have to actually prove damages to succeed on the claim. You still have to prove damages to receive damages, but and that's citing Clark versus the Spokesman Review, Idaho Supreme Court, 2007, which itself cites Goff versus Tribune Journal, Idaho Supreme Court, 1952. See also Sadid versus Vias, District of Idaho, 2013. So Guillard adamantly states that the statements she made about the plaintiff are substantially true. But you present no evidence. You say they're true, but you present no evidence. You have not presented a scintilla of evidence. There's nothing. Adamantly stating that your statements are true are not evidence. Scofield has the burden of proof and has not submitted convincing evidence that the statements Guillard made are false. Guillard's ideas are presumably and legally true. The fuck they are. That is a misstatement of the law. That is made up. That is fanciful bullshit. I would get sanctioned for that. I would get sanctioned for that. It's that egregious. Truth is an absolute defense against defamation. See New York Times versus Sullivan, Supreme Court, 1964, and Time Inc. versus Hill, Supreme Court, 1967. True ideas and statements cannot be defamatory. The plaintiff's complaint does not meet the elements of a defamation claim. Therefore, Professor Scofield is not entitled to judgment as a matter of law. The plaintiff has the burden to prove Guillard's ideas are false. The plaintiff erroneously places the burden of proof on Guillard in her motion for summary judgment. But, once again, Ashley Guillard, Okay. We'll take this quote that Ashley Guillard took from New York Times versus Sullivan. Truth is an absolute defense against defamation. The key word there is it's a defense, an affirmative defense. Who bears the burden on an affirmative defense? The person asserting defense. So, when Ashley Guillard says, well, the plaintiff erroneously places the burden of proof on Guillard in her motion for summary judgment, wrong. The burden of the affirmative defense of truth rests on Ashley Guillard, the defendant, who is asserting it as an affirmative defense. It's called burden shifting. The plaintiff bears the burden of persuasion at trial and bears the initial burden of production in summary judgment. Citation fucking needed. The initial burden of production in summary judgment. What is production in summary judgment? Seriously, what the fuck is she even talking about? I don't know. I legitimately do not know what she means by the plaintiff bears the initial burden of production in summary judgment. I do not know what she is trying to say. I don't. I don't. And what if it's a summary judgment motion brought by the defendant? Then what? Ashley Guillard could have brought a summary judgment motion on her own. She didn't. She missed the deadline. But she could have. Then what? Then what? Then who has the burden for the summary judgment? Who has the initial burden of production and summary judgment if the defendant brings the motion for summary judgment? I don't know, because I don't know what the fuck that even means. But seriously, the plaintiff in a civil lawsuit has the burden of proof of preponderance of the evidence. The burden of proof for a defamation case also rests on the plaintiff. See Gertz versus Welch, Supreme Court 74. Additionally, the plaintiff must prove that the alleged defamatory statements are false. See New York Times versus Sullivan and Time Inc. versus Hill. Scofield has not produced clear and convincing evidence that Guillard's ideas are false. Why is the burden on Professor Scofield now clear and convincing and not preponderance? I mean, this is a non sequitur. The plaintiff in a civil lawsuit has the burden of proof of preponderance of the evidence. Professor Scofield has not produced clear and convincing evidence that Guillard's ideas are false. But you said here she has to prove by preponderance of the evidence, not clear and convincing evidence. This bitch doesn't know what she's talking about. She needs to hire a lawyer. I mean, it'll be wasted money because she should have just said, yeah, so here's all the money I have. Please don't sue me. That would have been a better use of her time and money. Instead, Professor Scofield's evidence supports that. Wait, So instead, Professor Scofield's evidence supports that Guillard's allegations about Professor Scofield were not investigated by Moscow Police Department nor the University of Idaho. Therefore, because Guillard's promulgated ideas about Scofield's role in the murder of the 4 students and affair with the student have not been investigated, and there is no evidence to prove their falsity, the legal disposition remains that Guillard's promulgated ideas are true. Wrong! That is not the standard. That is not how any of this works. That's not how this works. This is made up. This is... In other words, it is legally true that Scofield hired an unexperienced hitman to commit the murders of the 4 University of Idaho students, and it is legally true that Scofield had an affair with a student. No! No, no, no! 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 Bad psychic. Bad. No. She's making up laws. Does she think she's the Supreme Court now? Guillard's ideas are not false statements of fact. The term misrepresentation of fact is defined as a false statement of substantive fact or conduct that leads to a belief of a substantive fact material to proper understanding of the matter in hand, made with intent to deceive or mislead. See 41 U.S. Code Section 7101, sub 9. Being 7101, this is going to be a definitions section. And in the definitions, it's going to say, for the purposes of this section, this is the definition of these terms. Remember how she tried to use the definition of defamation, section 4001, which is a definition of what defamation is for the purposes of collecting on foreign defamation judgments. It's in this chapter. Notice I said 7101 would be definitions. In this chapter. So for Idaho state law claims, that's not this chapter. So you may as well be citing to Harry Potter. Seriously. It means absolutely nothing. Oh, hey, this is for contract disputes. And this government contracting. So if I have a contract dispute between myself and Verizon, why would I? Because I don't use Verizon. But if I did, these definitions wouldn't matter. Because it wouldn't. Verizon isn't the federal government. I'm not contracting with the federal government. It wouldn't matter. It wouldn't matter. So, the term misrepresentation of fact is defined as a false statement of substantive fact or conduct that leads to a belief of a substantive fact material to proper understanding of the matter in hand, made with intent to deceive or mislead. A false or fictitious statement or representation is an assertion that is untrue when made or when used, and that is known by the person making it to be untrue. That's U.S. versus Worthington, Second Circuit, cert denied in 1987, and Second Circuit would be New York, Mid-Atlantic, not Ninth Circuit, which is what Idaho is. Guillard's statements were made in the best interest of public safety and with the intent to help solve a horrific crime. 4 students were murdered. She believes that her idea helps the crime to get the right people arrested. Guillard's tarot readings have a track record of being accurate, as exemplified by her intuitive that accurately predicted the untimely death of Staff Sergeant. Therefore, the promulgation of her ideas is not reckless, careless, nor an intentional lie. The potential benefit and value derived from her ideas, the arrest of quadruple murderers, far outweighs potential damages, especially considering Professor Scofield did not suffer any damages. Guillard's ideas do not meet the intent of a false statement of fact and are deserving of exploration, exposition, and protection. Clairvoyance and the use of clairvoyance in law enforcement is not implausible. In previous dockets, the court erred in deeming claircognizance and derived ideas as arguably so outrageous as to be clearly baseless and thus implausible. See docket 49, page 9. However, the CIA recognizes that psychics have been helpful in providing law enforcement with unknown information, which was helpful to their case. Recognizing that the investigator might develop a theory about the case and ignore important clues that could be highlighted by a psychic. In cases with a large number of suspects, the psychic could help the investigator concentrate on more likely suspects early in the investigation. That's footnote 4, a CIA reading room doc. And I'm going to go out on a limb and say that document probably says, yeah, so it's an outside perspective and psychics don't actually have clairvoyance. They're just good at reading people, and you get the psychic in and they might help you zone in on the right suspect because they're reading people. It's like the show Criminal Minds, FBI profilers, the BAU. They're doing the same thing psychics do. Really. They're reading people. They're looking for clues in behavior, analyzing that behavior. That's why it's called the Behavioral Analysis Unit. But that's exactly what psychics do. And so the reality is you'll have just as good results depending on the view as psychics, since they're doing the same thing. They're doing the same thing because how would Sir Sick word this? Psychics, they don't do the real. They're not real. Well, I mean, they are real, but clairvoyance isn't real. So, Guillard's claircognizant abilities and spiritual connection is authentic and elite. it is unlawful to deem the information she provided as false simply because she was not physically present. As stated by the CIA, it is not required for clairvoyants to be physically present to gather and provide information. Yet, the information can be helpful to law enforcement cases. Yeah, give the psychic no information other than, here's the victim, tell us what happened. Without giving any other information about the victim, about where they were, where they disappeared from, what their family situation is. Don't give them any other information. And really, it's just going to be guesswork. It's going to be made up. They might get some things right by accident. But, Ashley Guillard, she had to go on the internet. Tell me that Professor Scofield's the murderer without going on the internet, without searching. Say, if I had seen the murder, seen the report of the murders on the news on November 13th, 2022, and I said, yeah, in about a month and a half, the police are going to arrest a guy named Brian Koberger. That would have been impressive. That's not what she did. Conclusion. For the reasons stated herein, Guillard's intuitive ideas that Professor Rebecca Scofield hired men to murder and ensure the murder of the 4 University of Idaho students is presumed to be legally true. Except it's not. That's a misstatement of the law. Guillard's intuitive idea that Professor Scofield had an affair with one of the victims is also presumed to be legally true. It's not. The plaintiff has not been proven the statements to be false. That's some good English there. Unless the plaintiff agrees that the statements Guillard made are true, the truth or falsity of the statements are still in dispute. Therefore, the plaintiff does not meet the criteria for a summary judgment as required by Rule 56. Additionally, the plaintiff has failed to claim a valid defamation claim because the truth cannot be defamatory. The plaintiff's motion for summary judgment must be denied. Prayer for relief. Deny the plaintiff's motion for summary judgment. Award defendant Ashley Guillard all court-related fees and sanctions pursuant to Rule 11C in the amount of $1 million pursuant to B. Chambers v. NASCO, Supreme Court, 1991, footnote 5. Sanctions totaling nearly $1 million were upheld by the Supreme Court for the petitioner's attempt to manipulate the court of jurisdiction by acts of fraud, filing false and frivolous pleadings, attempting by other tactics of delay, oppression, harassment, and massive expense to reduce the respondent to exhausted compliance. Which none of that has happened here. That's asinine. That's ridiculous. That is bonkers. Bonkers with a capital B. So, looking at number docket 66, procedural history. Okay. So, I guess we do need to read from here. So, legal standard and argument. This is as to punitive damages. So, the plaintiff's complaint does not meet the standard for punitive damages. The plaintiff's entire complaint is completely fabricated and fraudulently filed. It does not meet the criteria for punitive damages as established by Idaho Code Section 6-1604. Pursuant to Idaho Code 1604-1, In any action seeking recovery of punitive damages, the claimant must prove by clear and convincing evidence oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. The defendant admits to communicating on social media that Professor Scofield ordered the murder of the 4 University of Idaho students to prevent from being exposed for having an affair with the student. However, Guillard did so in a noble attempt to help law enforcement solve the crime and for justice. This is exemplified by Exhibit A, Guillard's tip she sent to the FBI tip line. Murder is a public safety issue. She wanted to help solve the crime, as so did other members of the public who sent thousands of tips to law enforcement and reported their findings on social media, news media, and television. Additionally, Guillard believes that the statements she made regarding the murders and the affair between Professor Scofield and the student are substantially true. Malice requires that the statement was made with knowledge of its falsity or with reckless disregard of whether it was true or false. That's, once again, New York Times versus Sullivan. The plaintiff has failed to provide clear and convincing evidence that Guillard's conduct was malicious, outrageous, or ill-intended. The motion to amend the complaint to add punitive damages must fail. The plaintiff's complaint is fabricated, promulgates a false narrative, and is misleading to the court. The plaintiffs intentionally misled the court and public with the false narrative that Guillard intentionally made up false stories and published false statements about Professor Scofield to TikTok to use the tragedy as an opportunity for pecuniary gain. The plaintiff and her attorneys chose to lie to the court about Guillard's intent and character because they intended to abuse the judicial system to embarrass Guillard, humiliate her, destroy her spiritual practice and character, and to prevent Scofield from being investigated for murder. Guillard has proven that her character and behavior is not so outrageous. She did not lie. She did not make up stories about the tragedy for pecuniary gain. She did not post false statements about Professor Scofield knowing they were false. Instead, she used her highly developed and highly studied claircognizance to help solve a quadruple murder. She was motivated by purpose, not profit. The plaintiff's dishonesty with the court and the public does not warrant an opportunity to amend the complaint to add punitive damages. The plaintiff does not have and will not get clear and convincing evidence that Guillard acted with malice, ill intent, fraud, or oppression because, just like her false narrative, the evidence does not exist. On the contrary, Guillard has evidence that she has not acted with malice, ill intent, fraud, or oppression. The motion to amend the complaint to add punitive damages must fail. Amending the complaint to add punitive damages is not in the best interest of justice. Pursuant to Rule 15A2, and let's take a peek at that, amended and supplemental pleadings, A2, other amendments. In all other cases, so this is amendments before trial, in all other cases, a party may amend its pleading only with the opposing party's written consent or the court's leave. The court should freely give leave when justice so requires. So here, it's Professor Scofield has asked for leave to amend. Well, she's not going to receive the opposing party's consent because Ashley Guillard doesn't consent, or the court's leave, and the court should freely give leave when justice so requires. Now, let's look at it this way. Since local rules, Idaho rules, don't allow you to ask for punitive damages in your complaint, you have to ask for them later, but you have to amend your complaint to do so. This was when they could amend their complaint to do so. Justice so requires if punitive damages are appropriate to ask for, this is when justice, frankly, requires. This is the only time justice even allows the amendment to ask for punitives under Idaho rules. Therefore, under my reading of 15A2 of the Federal Rules of Civil Procedure, based on Idaho law, the court must, assuming, of course, that the requirements to ask for punitives are met. I believe they are. We're here. So, pursuant to Rule 15A2, a party may amend its pleadings only with the opposing party's written consent or the court's leave. No. That's a misstatement of the law. Here she says, and she puts it in italics, which is the wrong formatting, but this is all in italics, making this a quote, presumably. It's wrong, but presumably this is a direct quote. But a party may amend its pleading only with opposing parties, written consent or the court's leave. But looking at this, in all other cases, a party may amend its pleading only. So she left out the in all other cases. Because to Ashley, hey, you can only amend your pleadings here. But hey, as a matter of course, a party may amend its pleading once as a matter of course, no later than 21 days after serving it. Or if the pleading is one to which a responsive pleading is required, 21 days after service of a responsive pleading. And so if it were 21 within 21 days of the service of the initial complaint, you get one free do-over. You can amend without permission as a matter of course. But according to Ashley, only with the opposing party's written consent or the court's leave. That's false. But the court should freely give leave when justice so requires. First, wrong. First, defendant Ashley Guillard does not consent to the plaintiff amending her complaint to add punitive damages. Secondly, adding punitive damages to a frivolous complaint that was perjuriously filed with a false narrative is not in the best interest of justice. In fact, the plaintiff's entire complaint is an impediment to justice. The plaintiff in a civil lawsuit has the burden of proof by a preponderance of evidence. The burden of proof for a defamation case also rests on the plaintiff. The plaintiff must prove that the alleged defamatory statements are false. After 1 year of litigation and end of discovery, the plaintiff has not proven with clear and convincing evidence that she did not order the murder of the 4 University of Idaho students and that she did not have an affair with Kayla Gonsalves. Once again, you say preponderance of evidence and then, but she hasn't clear and convincing evidence. Which standard are we using? Why does it matter if Professor Scofield hasn't proven by clear and convincing evidence? He doesn't have to. You said right here, the standard is preponderance. You said right there, the standard is preponderance. Now, if Professor Scofield were a public figure, she's not. She may be a limited public figure for some purposes, but she doesn't apply here. She's not a public figure. If she were a public figure, she would have to prove that Ashley Guillard had actual malice. Actual malice for the purposes of proving for proving actual malice in order for a public figure has to be by clear and convincing evidence. So when Johnny Depp sued Amber Heard, Johnny had to prove by a preponderance of the evidence that he was defamed, that Amber Heard made statements, they were false, they damaged Johnny. But he had to show by clear and convincing evidence that Amber Heard acted with actual malice. Here, Professor Scofield is under no such burden. She doesn't have to. This is defamation per se because of the type of claims she made, Ashley Guillard made. Defamation per se is sometimes said to be actual malice, but it doesn't require the clear and convincing evidence. She's not a public figure. She doesn't have to prove actual malice. Now, defamation per se, she doesn't have to prove damages. She has to prove damages to receive damages, to recover damages, but she could get nominal damages saying, yeah, you were defamed, here's $1. Hope it was worth it. Professor Scofield has failed the burden of proof. Therefore, it is still legally presumed that the statements Guillard made are substantially true. No, you are misstating the law. You are making shit up. Stop. Just stop. Stop. People said way back when, before I fell so far behind, they said, Joe, you are going to lose your mind. Ashley has gone even more off the rails. And those of you who said that are right. This is unhinged. This is unhinged. So, therefore, it is still legally presumed that the statements Guillard made are substantially true. Those statements being Professor Scofield had an affair with the student and for students to prevent from being exposed. Without any convincing evidence after the close of discovery, it is not in the best interest of justice to allow plaintiff, a presumed murderer who has not been arrested, damaged, or punished in any way, to amend the complaint to add punitive damages. The plaintiff's motion to amend to add punitive damages must be denied. Guillard has not acted in a bad state of mind. The plaintiff errs in arguing that Guillard has acted negligently or in a bad state of mind by posting videos about her beliefs regarding the litigation since the beginning of the complaint. Unless proven to be defamatory, Guillard's statements regarding the murders and subsequent discussions about the complaint are protected by the First Amendment of the United States Constitution. Guillard's right to freedom of speech is not suddenly revoked due to the filing of a complaint. The plaintiff's argument that she can prove Miss Guillard acted oppressively, fraudulently, wantonly, maliciously, or outrageously, and can establish that Ms. Guillard committed a bad act with a bad state of mind because Guillard relied on her intuitive abilities instead of evidence is weak. Guillard is again protected by the First Amendment of the United States Constitution to believe in faith-based practices. The plaintiff again errs in her argument that Guillard acted maliciously by posting her ideas about Scofield's role in the murders after Brian Kohberger was arrested for the murder of the 4 students. Unlike Professor Scofield in this civil case, Kohberger is fighting criminal charges. He is presumed innocent until proven guilty. Get the fuck out of here. Yeah. Good. Good. Let's read this again, going back to the end of page 11. Without any convincing evidence after the close of discovery, it is not in the best interest of justice to allow the plaintiff, a presumed murderer who has not been arrested, damaged, or punished in any way, to amend the complaint to add punitive damages. So here, according to Ashley Guillard, Professor Scofield, who has not been arrested, damaged, or punished in any way, is a presumed murderer because Ashley Guillard said so. She's a presumed murderer. But here, unlike Scofield in this civil case, Brian Kohberger is fighting criminal charges. He is presumed innocent until proven guilty. Brian Kohberger is innocent until proven guilty. Presumed innocent and proven guilty. But Professor Scofield is a presumed murderer because Ashley Guillard said she's a murderer. That makes Professor Scofield a presumed murderer. She said, this bitch has said Professor Scofield is legally presumed to be a murderer. That's what she said. Presumed murderer. But unlike Professor Scofield, Kohberger is fighting a criminal case and he is presumed to be innocent until proven guilty. Professor Scofield is not afforded that presumption. She's a guilty bitch. But Brian Kohberger, by golly, the Constitution protects him. Not Professor Scofield. She's guilty because I said so. I hope you've enjoyed that feedback loop. The audacity of this bitch. Notwithstanding the fact that Guillard used clear cognizance to discern the truth of Kohberger's role and lack thereof in the murders, except by her fan fiction, he'd be guilty of conspiracy at the very least, because he performed an overt act to aid in the murders, but according to her fan fiction. The evidence Moscow Police Department detailed in the probable cause affidavit is weak. Oh, you're a legal scholar now. The evidence against Kohberger is weak because she says so. I mean, I don't know that it is the best case built against him. The defense is certainly fighting. I don't know that he'll be found guilty. I don't know that he won't. My crystal ball is in the shop. My tarot cards remain unshuffled. Guillard is not required to believe Moscow Police Department's account of events, that Kohberger, with no apparent motive, brutally stabbed the 4 students multiple times within 16 minutes, minus the time it takes to get in and out of his vehicle, somehow left with an exposed murder weapon, due to the sheath being left behind, with blood and DNA on it, yet left no trace of blood in his vehicle or on his person, walked directly past a witness without doing anything to her, despite being there just to kill for the alleged research, left without any harm to himself, and somehow murdered the student, 2 of the students first, but left while she or someone was heard crying in her room. As stated by the plaintiff, the Moscow Police Department did not believe Scofield or Guillard's ideas regarding Professor Scofield's role in the murders. Just the same, I do not believe in their illogical account of events. The Fifth Amendment of the U.S. Constitution guarantees citizens that no one shall be deprived of life, property, or liberty without following the due process of law. The 14th Amendment applies to this principle to the states in the U.S. In the case of criminal arrests and charges, the civil thing to do is to presume the citizen charged is innocent until proven guilty. Civility does not amount to malice or negligence. But saying Brian Kohberger is afforded the presumption of innocence is entirely different than saying Professor Scofield did it. A does not lead to B. Lastly, in Docket 64, the plaintiff argues, Ms. Guillard alleged Professor Scofield has photographs, videos, and messages from the night of the murder and during the murder on a collaborative book literature app she used to collaborate with the people she had help her plan and execute the murders. That's from Attorney Olson's declaration. Ms. Guillard claims in the video that anyone can get the photographs, videos, and messages from Professor Scofield by issuing a subpoena to her. But Ms. Guillard did not even do so in this case. So that's a quote from the motion for summary judgment. Back to Ashley. The plaintiff errs yet again. Intuitive tarot readings require logical discernment to understand the applicability of the message. Guillard discerned from the intuitive tarot readings that evidence could be found in a collaborative book literature app that has photos, videos, messages, and is collaborative. Guillard then attributed that message to be either a literal collaborative book application or Facebook, a collaborative app that people use to send messages, videos, and photographs. To test that idea, Guillard served a subpoena to Meta Platforms. The plaintiff filed a motion to quash the subpoena to Meta Platforms. The court granted the motion to quash the subpoena to Meta Platforms. the plaintiff fails to present a valid bad act argument against the defendant. The motion for leave to amend the complaint to add punitive damages must fail. You did not subpoena the messages from Professor Scofield. You wouldn't receive anything from that because it doesn't exist. Facebook, like literally subpoenaing Facebook is the wrong process. They're under no obligation to provide you with jack or shit. So the motion for leave to amend the complaint to add punitive damages must fail. Conclusion. For the reasons stated herein, Guillard's intuitive ideas that Professor Rebecca Scofield hired men to murder and ensure the murder of the 4 University of Idaho students is presumed to be legally true. Once again, a misstatement of the law. Guillard's intuitive idea that Professor Rebecca Scofield had an affair with one of the victims is also presumed to be legally true. We begin with the common ground. Under the First Amendment, there is no such thing as a false idea. However pernicious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. And that's once again Gertz versus Welch. Truth is an absolute defense against defamation. And that's New York Times versus Sullivan. Past the end of discovery, the plaintiff has not provided clear and convincing evidence that the statements Guillard made are false. She doesn't fucking have to. Clear and convincing evidence is not the standard. You say so or yourself. Besides which, she has. She absolutely has. Probably even to the clear and convincing standard, but she doesn't have to. Considering the plaintiff does not intend or desire to go to trial for the merits of the complaint, it is logical to conclude that she put her best case together. What? She doesn't want to go to trial because on the merits, because she doesn't have to, because by law, she wins at summary judgment. There is no issue of triable fact. None. Why would she desire to go to trial? That costs money. She makes $75,000 a year as a professor. That's a good income, don't get me wrong. But that's not a lot to pay for lawyers to go to trial. You can burn through more than that annual income in the trial alone. So why try issues you don't have to? They still have to go to trial for damages unless they settle. They still can settle. It's not going to happen, but they could. Her evidence includes the declaration from Professor Scofield, admissions from Guillard that does not add value to her case, and TikTok videos from Guillard posting content that has not been proven false. It simply isn't enough evidence to prove her defamation case by a preponderance of the evidence. So we're back to preponderance, not clear and convincing. The plaintiff has not proven her case. Therefore, a legally presumed murderer does not get to sue a whistleblower for punitive damages. The plaintiff's motion to amend the complaint to add punitive damages must be denied. She seems to be hinging her argument against punitives on her argument against summary judgment. Prayer for relief. deny the plaintiff's motion for leave to amend the complaint to add punitive damages, award defendant Ashley Guillard all court-related fees and sanctions pursuant to Rule 11C in the amount of $1 million pursuant to B. Chambers versus NASCO, a Supreme Court case from 1991. Now, I know we've done this before, but let's take a little look-see-poo at Rule 11C once again, shall we? Because this bitch is doing it wrong. Rule 11, signing pleadings, motions, and other papers, representations to the court, and sanctions. So, 11A, signature. How do pleadings need to be signed? B, representations to the court. And C, sanctions. In general, after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated. The court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. A motion for sanctions. 11C2. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that allegedly violates Rule 11B. The motion must be served under Rule 5, but it must not be filed or presented to the court if the challenged paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service or within another time the court sets. If warranted, the court may award to the prevailing party the reasonable expenses, including attorney's fees, incurred in the motion. So, what are the problems with this? Ashley Guillard asks in her prayer for relief, which is appended to the opposition to the motion to amend, motion for leave to amend the complaint to add a request for summary judgment or for punitive damages. Ashley, in her prayer for relief, says, deny that motion, and according to 11C, give me $1 million. Well, a motion for sanctions must be made separately from any other motion. Well, couple problems with that here. Number one, this is not separate. This is just tacked on. But also, this isn't even a motion. This is an opposition to a motion. Not a motion. Not a motion. You have to bring a motion, and it has to be a separate motion. It can't just be tacked on as a prayer for relief in an opposition to your opponent's motion. Also, looking at C1 in general, if after notice and a reasonable opportunity to respond. Notice. I will bet you there's no email from Ashley after receiving Professor Scofield's motion saying, so I'm putting you on notice that if you don't correct this, I intend to file a Rule 11C motion for sanctions because I think you violated Rule 11B by doing this. Please fix it. If not, in 21 days, I shall file my motion for sanctions. I bet you there is no. I mean, there's no motion. There is no separate motion for sanctions either. But I bet you there's no notice. There's been no reasonable opportunity to respond. Where have we heard those terms before? Notice and an opportunity to respond. By golly, those are the basics of due process. By golly, gee willikers. Isn't that fancy? Well, and that was also submitted on February 2nd of 2024. And I lied. I said we would, getting back to the docket, that was 65 and 66. I said we'd get through 67 and 68 as well, but I lied because the audacity of this bitch took longer than I planned. So we're going to call it a night. I will see you next time to do 67 and 68, the replies to these train wrecks that we just discussed. We might get a little more done than that too, but at the very least, we'll get through the replies. So, with that, do all the YouTube-y things, like, share, subscribe, bribe your friends and family to do the same. To the members, happy Saturday, because you're getting this early. To everyone else, happy Sunday, unless you're in Australia, then add a day to that. I'm looking at you, 65 CJ5. So, yeah, as aggravating as that was fun. I have missed this. So, see you soon for the next one. Bye-bye.